All right, welcome back. Thank you. Hope you all survived the midterm. I have all of your papers. I have not started reviewing them yet, but I'll be doing that very soon. My goal is to have them all graded by November 1st. It's about 2 weeks from now, which is pretty fast. I'm going to go as fast as I can, but November 1st. In any event, the sessions to review them will begin November 3rd, November 4th, and November 11th. If you haven't signed for a slot, please do so as soon as possible. A lot of the good slots are already taken, so at this point, you're stuck on November 11th. And the purpose of these is to go over your exam carefully. Before the deadline, when these exam meetings begin, I will return your papers to you. You can pick them up. I'll also give you the question itself. I will give you the A+ answer. That's a student who scored the highest score. It'll be anonymous. Won't put the person's name on it. And I might also do a memorandum explaining my thoughts on the exam. Okay? Yeah, Mia.
When you say pick them up, you mean tangibly?
Yeah, they'll be in Cindy's office. Her office is right across the hall from mine, so you just pick them up from her office. Probably in, I think November 1st is a Thursday. We'll be ready that Thursday. Okay? All right, any questions on that? No? All right, so moving on to today's class, you might ask, why do we have such a hodgepodge, right? Usually the classes have like a theme where the cases sort of fit together. And today they're really over the place. And they take place over the course of like almost 3 decades. So why am I lumping together Meyer v. Nebraska, Pierce v. Society of Sisters, Buck v. Bell, West Coast Hotel v. Parrish, United States versus Caroline Products, and then Lee Optical, right? Why am I lumping these cases together? They all involve a common thread. And the common thread is, can courts decide whether any particular legislation is not proper, that it's unconstitutional, that it violates some sort of right? And all of these cases, all of them, turn on basically one word in the 14th Amendment, which is the word liberty. Right? We all know the state can't deprive you of liberty without the due process of law, but the Constitution doesn't say what liberty is. And what you see with these 6 or 7 cases are very different approaches to courts construing the word liberty in very different fashions. So I want to start the class with a question that I alluded to in one of the scripts. If you read the Buck v. Bell script, you already saw this question. But I want to ask this question. And I framed it a little bit differently this year than I did last year. I'll see if I get better, more accurate results. So the question is this. Which is a greater deprivation of liberty without due process of law? Compulsory sterilization for imbeciles, or a life-term commitment in a sex-segregated prison? I asked it differently last year, and it didn't work, so I'm trying it differently this year. I'll explain why it didn't work last year. We'll see what happens this year. Which is a greater deprivation of liberty? Forcibly sterilizing so-called imbeciles, or locking them up in life in a sex-segregated unit? And again, there's not a right or wrong answer here, but it's supposed to make you think about how the court in Buck actually reached the result that it did. I know you want to do none of the above. I know that's not an option. Don't put C. Someone's going to put C. You're going to ruin it. All right, so I think everyone done? Anyone else? So, all right, 5 more seconds. Okay, I'm gonna stop it here. Okay, let's see what we got. Ooh, all right, wow. Okay. All right, so why the hell did I ask this question, right? What kind of insane, what kind of, I trust me, I got a reason, don't worry. I think these things through. Whether they work or not, I don't know. But there are lots of things that the state can do to you. You say, oh my God, that's a deprivation of my liberty, they can't do that. And that's a deprivation of liberty. So let's start with a very easy example, which comes up in Buck, which is the military draft. If the government can conscript you into service in the army, where you're probably going to go to die, that's a pretty big deprivation of your liberty, I'd say. Right? Throwing you in a unit, sending you off to war where you might not come home. Can the government do that? So we have to ask ourselves, is being killed in war a deprivation of liberty? Yeah, sure, it is. Life as well, no question about that. But is it justified? And we have to consider 2 concepts which we've discussed throughout this course, which is the means and the ends. And this framework fits into each of the cases we're studying for today. Now, what do I mean, the means and the ends, right? Well, what's the means? Drafting someone into military service, right, where they might be killed. That's a pretty big deprivation of liberty right there. But what are the ends there? Well, preserving the nation, national security, you name it. If we don't have a military, we don't have a country, right? So then we ask ourselves, what is the fit between the draft and preserving the nation? And you might say, well, unless we have the draft, we won't have enough soldiers to fight, and then we won't exist as a nation. Well, maybe we'll have enough soldiers, maybe we can have robots, I don't know, make up your mind. But back in the day, we couldn't really do that because we didn't have robots. But sometimes the state's end, their interest is so great, is so compelling, that it overwhelms the fact that what they're asking for is a very big ask, right? A very big burden on individual freedom. So we say perhaps with the draft, the ends justify the means. You know that expression, right? You never really thought about what it meant. The ends are justified by the means. But then you have a case like Buck, which we'll get to in a couple minutes. Tough case every time I teach it. The government has the power to commit people. What does it mean to commit someone? Lock them up for life. Now, today we think of committing someone because they are, a danger to themselves or others, right? We have institutions for that. You don't get a jury trial for that. The government doesn't have to prove beyond a reasonable doubt they committed a crime. In fact, you may have never committed a crime. You can commit someone based on a risk that they may commit a crime in the future. That's a pretty significant deprivation for liberty, isn't it? Right? You're basically locked up because some judge said, yeah, you're dangerous, and you're going to be in this commitment institution for the rest of your life until I deem otherwise. So we all agree that the state can lock someone up indefinitely, whether they've engaged in any sort of misconduct or not. Like a pre-crime almost, if you will. But then we go to the law at issue in Buck. The government says, well, look, we can lock up Carrie Buck for the rest of her life, or we can give her a minor procedure, sterilize her. 1 day in the operating bed, recovery, then she's free for the rest of her life. She can't reproduce in either context, which is why I framed the question this way. She's in a sex-segregated unit. She cannot reproduce in an all-women's unit. So either she can't reproduce in this unit where she's locked up her entire life, or she can't reproduce out in society because she was deprived of the biological means to do so. So the question, Buck, was this: which is a greater deprivation of her liberty? Right? Locking her up for life, or giving her this surgery against her will, and then letting her go and she can live her life just minus reproduction. So Buck v. Bell is a very easy case to say, oh my God, this is awful, and it is awful. But I want you to grapple with the actual underlying issue. If the state has the power to commit someone for life, a far greater deprivation, can they do the lesser? Now, your numbers say the opposite, right? About 60% of you said that the sterilization is a greater deprivation of liberty, and about 41% of you said that the life-term commitment was a greater deprivation. And I think the way you approach this question largely impacts how Buck v. Bell comes out, right? So I guess for the 40% of you who said, I'm not going to call on people for this, don't worry, but for the 40% of you who said B, then Holmes made at least some point, right? That if they can do the greater deprivation of locking you up, why can't they do the lesser deprivation of the sterilization? And you don't have to agree with me, you can think it's insane, but once you get that framework, you start understanding how these cases work. A judge is making a value judgment about what is and is not an acceptable intrusion onto individual freedom, right? A judge is making that value judgment. Now in Buck, it was 8-1 vote, so 8 judges were in the, that other camp, and 1 judge was in the other camp, right? And then you have in Meyer v. Nebraska and Pierce, you have similarly lopsided votes the other way, that the restrictions upon education or where you can go to school, that was such a great deprivation of liberty that it wasn't supported. One second, I'm almost done ranting. Yeah, almost done. But then you go to a case like Lochner or Atkins, where the deprivation of liberty was restricting how many hours you can work, what your wage might be. And that deprivation was so great. But you can't compare apples and oranges, because you have to also think not just the means, but also the ends, right? What was the end the government was trying to pursue in Buck v. Bell? They said the preservation of the human race. This was the basis of eugenics, right? So if we don't do this, we'll be extinct as a species. Right? So it was such a compelling interest for the majority that they're willing to tolerate this intrusion. All right, so as we go through today's lecture, just keep this in mind. I know the thread is very faint, but it's there, of how the judges make value judgments between the means and the ends, and then ask do you want judges making these value judgments? And if you say no, and they shouldn't be making these judgments, then it becomes, can the legislature make these value judgments unilaterally without being questioned by courts? Right? Because again, Virginia enacted the sterilization law. It went through the democratic channels. It was a fairly popular law, and then was enacted in a number of states after that. Okay, I'll stop now. Mia?
Oh, I can see it.
Good. Glad I did. Hey. Okay.
Was this?
Yes, Monique.
But just a question.
Please.
Is back then, because I know now in prisons, even in women and men prisons, the guards are men and they still have sex with inmates all the time.
Yeah, you're finding the hypo, but it's a good point. Yeah, it's a fair point.
So back then, was it like that too?
I'm sure. I mean, in my hypothetical, I didn't consider that, but I'm sure there's a chance of.
Because the only reason I say that is because in that case, you still have the chance, the opportunity.
Oh, I see what your point is. Okay, because the guard might.
You can have sex with the guard, and you can still have the ability to reproduce. Whereas if you completely don't have the ability.
Oh, I see. All right. Well, assuming the hypothetical that's at sex segregated with all female guards.
Okay.
Which I don't think was a thing back then, but yeah, it's a fair point, right? Okay. And by the way, just to Monique's point, if a guard did impregnate a female, she would almost certainly have to give her child. Because I don't think she'd be able to even raise the kid were she in that unit. So I mean, I guess you could carry the child to term in theory, and then you'd have to give it up. I'm sorry?
Isn't that what happens in real life?
To Carrie Buck?
in prisons today.
I believe that's right. I think that's correct. Just one at a time. Yeah, Janice, yeah.
So the sterilization, I can't remember. It was only to sterilize the women.
Men were sterilized as well.
Was it? Because I didn't.
Yeah, no, it wasn't in this case, but men were subject to the sterilization order as well.
Okay.
Yeah. Less invasive procedure, sure, but they got it. Same. Yeah, Mia?
So, I
Guys, just one at a time, please.
I thought the purpose in Buck v. Bell was that they were preventing the people from being a drain on society by like having children and who would then become criminals or
Right.
would go and starve because they couldn't fend for themselves. But so how does that tie to their commitment though? Like
Because
they're just like false.
Because how do you prevent people from...
choices.
No, it's not. How do you prevent someone from reproducing? You either prevent them from having sex.
Apparently not by law.
Well, no. How do you prevent them from reproducing? Prevent them from having sex, or if they have sex, they can't reproduce, right? So you can either say, we'll prevent you from having sex by locking you up 24/7, or we will release you and have sex all you want and just you can't regenerate.
Are they locking these people up to prevent them from
Reproducing. Yes.
Or are they locking these people up because they couldn't themselves fend for themselves?
No.
or-
That's the important point. Before the eugenics law,
You could just
Bef-
lock people up so
just-
they couldn't have kids?
yes, that was the law. That's why there were sex-segregated colonies. Before, guys, one at a time. Before the Virginia law went into effect, the way they accomplished this was by locking people up indefinitely so they couldn't reproduce until they were no longer of reproducing age. They had actually let women out when they were of no longer of reproducing age. And they said a less severe, a more humane alternative to locking someone up for 35 years at great cost was to give them this procedure and this surgery. This was considered the more humane alternative to locking up these degenerates, as they call them.
We suck.
What?
I said we suck.
No, not all of us. No, we don't all suck. Because that's the point that I think we've been talking about, right? Is that a lot of these, for a court, Supreme Court justices to find things like that to be constitutional, these are the people that are making the rules that we have to live by. These are the people that are making the decisions.
Well, who made the rule? The legislature or
Well,
the
but
justice?
They upheld it.
They upheld it. So it's
it's
both.
the same thing. The Supreme Court's supposed to be checks and balances on the different governments and legislation, and then the judicial system. But then you have the judicial system that upholds it. So these are the people that are making the law of the lands, and they're saying that it's the more humane thing to do is for you to be God and determine whether or not who can reproduce. Somebody might have thought your mother shouldn't have had you.
I think the
Marcus?
I think the justices weren't allowing it more than they were giving the states the right to police their people.
That's not a liberty.
There's one time. Just guys, just through me, not back and forth. Yeah, thanks. I know. Just this way, Marcus.
Yeah,
Yeah.
I mean, because I see that's how the opinions are kind of written, in the sense to where they're allowing the states to exercise the right to police their people
All right.
for general welfare.
I don't agree with that. That's not policing. Their police states doesn't say that's that takes policing too far, right? Like for you to determine who can have children and who can't. That's not the health. I understand how they in their twisted way they can make it be for those things that the state has police power. But how is it your call whether or not somebody gets to reproduce? And then according to the facts, they didn't even have they didn't have it straight. There was underlying circumstances that related to her.
So let me try and address both of their points, I think, which are fair, right? What is the police power, right? Does the police power include the right to tell people where to go to school? What languages they can learn? How many hours a week they can work? Whether they're free to be out in public or they're in jail? Whether they're free to reproduce, right? What are the bounds of the police power? And that is the scope of our lesson today. All right, much more points. I'll move back onto Meyer. We will get back to Buck, I promise. Is there another hand somewhere? Yeah, go ahead.
Say I don't actually agree with it. I've been dreaming a lot here.
We're all friends here. Okay. Who's up? Who's up next? Who's the next one? Yeah, Lucian, you want to give me the facts, please, in Meyer v. Nebraska? Whoa, okay. So tell me about the law that Nebraska enacted. What law did Nebraska enact?
They passed a law that made English the. I gotta pull up the case book.
You want me to come back to you?
Yeah.
Okay, I'll come back to you in a minute. Who we got over there? James?
I didn't get to this reading.
It was the first case.
I didn't get to reading.
What did you get to?
I didn't do the reading for today.
Okay, that's a better answer because I'm calling you in a few minutes. All right. Just don't say I didn't get to it. That means I'm going to call you later. Justin?
So they passed legislation that prevented teachers from teaching modern languages. It was okay for them to teach like Hebrew or Greek, I think,
Right.
Latin, but not languages. And this section 1 says no person individually or as a teacher shall in any private, denominational, parochial, or public school teach any subject to any person in any language other than the English language.
Okay, very good. Justin, why did Nebraska enact this law under their police power?
Well, they said the end was to make all citizens speak a common tongue.
Why? Give me one step more. Why were they so interested in all being Nebraskans having a common tongue? It's not, I don't think it's in the case. But why do you think they were so intent on having a unified common language?
Maybe to discriminate against the people who, immigrants.
Yeah. I think that's a fair answer, yeah. If you notice, they excluded certain languages like Latin and Greek and Hebrew and things that were like, sort of elite languages. And immigrant languages like German or Spanish or Italian or whatever was basically prohibited. This was an assimilation measure. There's no other way to do it. It was to make everyone, immigrant or not, learn to speak English. And this wasn't just a provision for the public schools, right? Schools can dictate what they learn in public schools. Here they went after a private school. It was a religious school. It was a Lutheran school, if I remember, right? It was a Lutheran school where they were basically teaching Bible verses in German. Now, if this case came to the court today, it would probably be what's called a free exercise case, right? Because they went after a religious school teacher. It would violate the First Amendment, I think. But at the time, the First Amendment didn't really play a role. Why? Barron v. Baltimore, my friends. At the time, the First Amendment still only applied to the federal government. The states could limit free exercise all they wanted. So when you read Meyer v. Nebraska, and the next case, Pierce v. Society of Sisters, those seem a lot like religious freedom cases, right? But they weren't. And in fact, the Pierce case had the military academy, which wasn't religious at all. So again, we have a case where the teacher, Mr. Meyer, was fined, was it $25 for teaching some German Bible verses in his religious school. The court of Nebraska upheld his conviction. He appealed his case to the Supreme Court. Right? So Andrew, what did the court do with his case?
Reversed it.
Okay, tell me why.
Well, the last paragraph, there seems no adequate foundation to the suggestion that the purpose was to protect the child's health by limiting his mental activity.
What does that mean?
That means that the means do not justify the end.
Okay. Why? What exactly was the liberty interest? Andrew, you're really close. What exactly was the liberty that the state was depriving Myers of? Because again, this wasn't a case where a student was punished for learning, right? This wasn't the right of a student. It wasn't a parent. It was a teacher. It was a teacher who was thrown in, who was getting punished. Andrew, what exactly was the liberty interest here?
The right right to do your job how you
Yeah. Not what you expect with this case, right? It was basically a Lochner-esque case, that you have the right to pursue a common calling, which is teaching, right? They say the legislature interfered with 3 rights here. The right of the teacher to be a language teacher, the right of the students to acquire knowledge, and also the power of the parents to control the education of their kids, right? It's a trifecta, hit all 3. And the court said that is a violation of the Due Process Clause of the 14th Amendment. You have to understand this case as being decided in the vein of Lochner. This wasn't a free speech case. It wasn't a free exercise case. It was about the right of the teacher to work. And they were criminalizing a lawful activity of a teacher giving foreign languages to his kids. It didn't matter that these were Bible verses, right? That was not part of the court's decision. So then we have Justice Mcreynolds, right, who's the majority. Mcreynolds was he's probably one of the least, after Tawney, among the justices who were not well liked, he's on that list. He was a virulent anti-Semite. Virulent. When Justice Brandeis was on the court, whenever Justice Brandeis would start speaking, he would turn his back to him. He was just an awful human being. He went to the University of Virginia Law School. You will not find a single portrait of the man on the campus of the University of Virginia, not one portrait. It's as if he didn't exist, right? It's your only justice, I think, and there's no reference of him even existing on the grounds of that campus. He was very conservative. You'll see him in the New Deal cases as someone who's always voting against the Roosevelt programs. But here he was very eager and very, I think, broad in defining these rights under the Due Process Clause. And he lists a bunch of them. I'll read them to you. He said the word liberty is not restricted to freedom from bodily restraint. It includes the right of the individual to contract, to engage in any common occupation of life, to acquire useful knowledge, to marry, to bring up children, establish a home, worship God, according to the dictates of his conscience, and the right to enjoy those privileges, long recognized at common law, as essential to the orderly pursuit of happiness by free men. So, where the hell did he get this list from? Right? Where did he get this list from? Oh, what a wonderful answer. Thank you, my fantastic. That's for the answer I had. I don't know where he got it from. But yeah, these are the sorts of rights that at common law were understood to be protected by any government. Right? Very good answer. Right? Contract. I don't know if marrying was in it, but it should be. Right? So these are the very important rights, which he's just gleaning. And he's saying, in my judgment as a judge, I think this is what liberty means. Now, compare Meyer decided a couple years before Buck v. Bell. Right? Freedom from bodily restraint. Sterilization sure as hell is bodily restraint, without any question in my mind. So the court found that the Nebraska law violated this liberty protected by the 14th Amendment. Okay? He acknowledges that the ends are permissible, right? That improving the quality of citizens mentally and morally. So he basically buys into the assimilation theory. But he says the means are not permissible. The means here prohibited. Right? The government can't interfere with liberty under the guise of protecting the public interest unless there's a reasonable relation to some purpose within the competency of the state. So if the government's actually interested in promoting public welfare, it can do so without this law. Maybe they can mandate English be taught alongside foreign languages, right? That would help. But by criminalizing these languages, just these specific foreign tongues, they say this is not a reasonable law and infringes on the 14th Amendment. All right. So any questions on the majority in Meyer v. Nebraska? We'll do the Holmes dissent in a minute. If you notice a pattern, Holmes dissents in every one of these cases. Every single one. And in fact, most case books don't even have the Holmes dissent. Mine, Randy's didn't have the last edition. I didn't even know it existed. Holmes dissented in another case relating back to this one. It wasn't even obvious, so I had to dig this one up. But he dissents everywhere. Even when he doesn't dissent, he doesn't publish it. He keeps them, but he dissents in every case. Sahar, you want to give me Justice Holmes' dissent, please, in Meyer? The case called Bartels v. Iowa, if I remember correctly.
So he first found that the law pursued the proper and desired end.
Okay.
Because all the citizens of the United States can speak the common language.
Okay.
He said the means of reaching that end were reasonable or even necessary to ensure that young men or young children shall hear and speak only English at school.
Mm-hmm.
And so he concluded that the law was not an act of arbitrary fear. He said that men usually might differ on the propriety of the law, but the Constitution does not prevent the experience of being tried by the state.
Okay, very good. Holmes here repeats his Lochner dissent, right? Remember in Lochner, he said the Constitution is not made for any one school of thought, not one economic school of thought. And he says the same thing for social policy, right? Reasonable men might differ on whether this law is appropriate. And the Constitution does not prevent experiments from being tried. Now, Holmes thinks that this is a necessary method to make sure people speak English. But even if it's not, he's not willing to second guess. So for Holmes, it's an issue of deference, right? What measure of deference does the state get when they're enacting social policy? Is it my job as a judge to say, is this necessary? Can the government do this with an alternate means? Maybe a different means can accomplish the same ends with a better fit. But that's not my job. Reasonable minds might differ. And for Holmes, if reasonable minds might differ, that's the end of the story for the judiciary. And so therefore, he would uphold the language law. So any questions on Meyer or the dissent from Holmes? Any question on Myers? Adrian, is that hand?
I just want to be clear. So you're saying his dissent is based on the fact that whether he agrees or not, it's not his, he doesn't think it's his place to object.
Mhm.
Because that's the state's decision to determine if they feel that's the appropriate means.
Yeah.
Is that-
I'd say it's not the court's role to second guess the judgment of the legislature. Very close to what you said, but I'll change object to second guess because you said it's not our choice. If they make that decision, that's their call. Yeah.
So, was Holmes the one that we said in the Lochner opinion, he kind of had that if the government does it, it's okay with him type of mentality?
Pretty much, yeah.
Okay.
Yeah, Holmes was the third opinion, the second dissent, where he said that if reasonable minds can disagree, the courts have to defer. It's not my role. Now, Holmes liked these laws. I'm sure you could tell he basically favors them as a matter of policy, but he doesn't let that, he doesn't hide that. Has there another hand somewhere? Yeah.
Yeah, I was just gonna say, it just sounds like his reasoning doesn't make sense to me, because he says if he says where reasonable minds might differ, then we just give deference. Well, obviously reasonable minds differ by the nature of it being brought there, because there's some people reasonably arguing that it
Well,
shouldn't be.
at least one mind thought this was a good idea, right? Which mind thought it was a good idea? Well, not just his for sure. At least one other mind thought this was a good idea.
Right.
Nebraska. So basically, Holmes' opinion, if a law makes it through the democratic process, it's constitutional. Right? I mean, if it makes it through the legislative branch and the executive branch of the state, that's good enough for him. That means at least some people in positions of power thought it was reasonable. Again, in Buchanan v. Worley, that was the Louisville segregation case. He had a dissent all ready to roll. Right? He had a dissent ready to roll and he pulled it. Right? He basically would have upheld every single law that came across his desk under the Due Process Clause of the 14th Amendment. He had some narrow exceptions for free speech stuff, which we'll talk about later, but that's an enumerated right. We have a free speech provision. But he would say the word liberty is not something for courts to interpret. It's basically just deferring to whatever the majority rules. Yeah.
So he believed in presumption of constitutionality.
Oh, what a beautiful answer. Yes, thank you. He applied an absolute, wasn't just a presumption of constitutionality. He basically said, screw it, constitutional, right? Yeah. Yeah, and I don't want to use Holmes as presumption of constitutionality. If you want to be precise, Harlan, right? Justice Harlan's dissent from Lochner was a presumption of constitutionality that can be rebutted, right? That you could rebut it. You can show this doesn't apply here. But Holmes's Lochner dissent basically means you can't rebut it. If the law made it through the democratic process, you're done, right? As long as you get your trial, whatever, you're done. That's all you get. And if you want to just break this down even more, Caroline Products, right? I'm jumping ahead, applies a presumption of constitutionality. Lee Optical, Williamson, Lee Optical, the last case, that applies the Holmes approach, where you can't rebut that presumption of constitutionality. I got a spreadsheet to show you. I made another timeline. I'll show it to you in a minute. Yeah.
So
Yeah, Mia, go ahead.
for Holmes, what is the point of retaining rights to the people?
None. Not for the judiciary to decide.
But that is their job.
Says who? No, I mean that sincerely. Says who? I mean, where does it say that's the court's job to enforce unenumerated rights? I'm asking this very carefully, but...
Well, I think that the fact that the Bill of Rights says that there are unenumerated rights and the foundation of the Constitution and who it was written by, including Madison, Jefferson, and people who wrote the Declaration of Independence, indicates that there are some unenumerated rights that exist.
And are those for the legislature or the courts to enforce?
Isn't it for the legislature to not contravene, and if they do, then the state is there to check that power?
But how do you know what those rights are? So let me take a step back. I'll show you this. I made a fancy timeline, which will be animated sometime after you take the exam, probably, unfortunately. So I'll show you this, my Google Doc. The Ninth Amendment, right? We've referenced it a few times. It says that, I'll read it to you. Sorry, to paraphrase. Wrong pocket. Right? So Mia referenced the Ninth Amendment. Right? It says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So Mia's right. The Bill of Rights says there are certain rights that are retained by the people. What are those rights? And who gets to decide what those rights are? The Constitution doesn't give a clear answer to that. Now, I do think that there's a role for judicial enforcement of the Ninth Amendment, but that's a minority theory. And there's nothing in the text that says it's for the courts. Right? But let me walk you through this timeline. I want to go back to Janice's, Adrian's question from a minute ago, right? So here we have a timeline, right? The presumption, you can view the due process clause as one of two presumptions, right? A presumption of liberty and a presumption of constitutionality. So we have these cases, right, during the so-called Lochner era, during the early 1900s. You have Lochner, which was the bakery case. You have Muller, which is the women walking in the laundry shop case. You have Buchanan against Worley, which was the Louisville segregation statute. And then you had Atkins, which was the minimum wage for the women in the hospital, right? 3 of those were struck down, and 1 of them was upheld. But in each case, the court applied what we might call a rebuttable presumption of liberty, right? Where the court starts with the presumption that the legislature is acting improperly. And it's up to the government to show that this law is justified. And if you remember the Brandeis brief, right? The Brandeis brief. All this evidence showing that women were feeble and they couldn't work that many hours. So the government had evidence showing why it was unconstitutional. In Lochner, the statistics weren't enough because baking was a safe profession, the court said, right? In Atkins, it was enough because women had now equality because of the 19th Amendment and women's suffrage, right? So the first phase, as we described, is a sort of rebuttal presumption of liberty. Okay, I'll put the link to this in the class blogs. You're not frantically. Sorry. Yeah, here. I'm sorry. I should have done that earlier. So then I'm going to scroll. Right? But then we have the cases that we're doing today. Right? Well, I cited West Coast Hotel. There's some other cases, but they do the same thing. In West Coast Hotel, right, we have what we might call a presumption of constitutionality that can be rebutted. right? Where the court starts off presuming that a statute's constitutional. They presume it's constitutional, but that can be rebutted. But then we get further on to 37, go to 38 with Caroline Products, where the court qualifies it. And they say, well, there's a presumption of constitutionality unless you have the stuff in footnote 4, which we'll get to later, right? Where there's certain discrete and minorities, or there's certain racial prejudices that may warrant not applying a presumption of constitutionality. But then we get to the last case, the fourth stage that we call it, right? Stage 4, where this is full homes, right? This is like Harlan in stages 2 and 3. Stage 4 is Mr. Holmes, where the presumption of constitutionality is irrebuttable, where if the legislature passes a law, that's it. That's the end of the story. So the story of the 20th century, right, if I can scroll, is you start off with the presumption of liberty in the Lochner cases. Then Harlan takes over with this presumption of constitutionality, can be rebutted. But as you get to the 38, 39, 50s, it goes full Holmes. So Holmes was never in the majority in his own lifetime. The court would only adopt the Holmes deference years later after the New Deal. So when you look at Holmes, you can say, wow, he's all by himself, which is fine. He was. But the case law approach that he advocated for was subsequently adopted later by the court, which is why I will keep coming back to Harlan and Lochner versus Holmes, right? Harlan and Holmes. No, Peckham's done, right? The presumption of liberty and Peckham, that one disappeared in the 1920s. That's gone. But the Holmes and Harlan one, those ones still have a lot of salience today. Does that make sense? Yeah. That make sense?
So, quick question then. So in stage 4, if the presumption is irrebuttable,
Yeah.
then who protects individual rights?
The democratic process. And that was, I think, Mia's question to me a minute ago, right? What the court basically says in the Holmes approach is the check is the ballot box. Unless, which is why footnote 4 does play a role, the ballot box is not working. So long as the democratic process is functioning, the court says, we're going to hands off.
So what's the purpose of the court?
For unenumerated rights, not much. But then we'll get to the Griswold and Roe case where they say never mind, right? If you notice, this timeline stops in the 1950s. Once you get to the 60s, all bets are off because you get to the contraception cases, the abortion cases, where they say, never mind, we didn't really mean that, right? So this entire thing is a representation of time up to the 1960s. And then after that, it sort of goes in a different direction, which we'll get to next week, I think. Yeah, Mia?
So the Holmes stage 4 doesn't have like the footnote 4 built-in exception for things like kind of like voting rights.
That's where the footnote 4 doesn't apply, right?
They don't have-
Once you get to stage 4, you're outside of when you're outside footnote 4, when there's not any sort of electoral or racial issue, then it's straight up presumption of constitutionality can't be rebutted.
But if there is an electoral issue?
Caroline Products still controls, right? But stage 4 is where it doesn't fit with one of the categories of footnote 4.
Okay.
We'll get to footnote 4 later today. There's a lot of stuff today. I wish I could split this in 2 classes. I probably will next year when it's 6 hours of ConLaw. Is there another hand? All right, so just walk through this history thing, right? So we have the Lochner cases, and then we get to Myers and Pierce. They fit really here. I didn't put them in the timeline because they're not economic cases. They don't really fit. But Myers and Pierce are decided right here. All right, so Lucian, going back to you. Did you read Pierce?
Yeah.
Okay, you want to give me the facts in Pierce, please?
Here is a law that was passed that said that we have the Oregon Compulsory Education Act. It also had in public schools.
Okay.
And there were 2 private schools,
Okay.
Society of the Sisters and the Hill Military Academy, that challenged this in the 14th Amendment.
Okay, good. So, Lucian, why did the state enact this law? What was the state's goal? What was their end to enact this law? Might not be in the case directly enough, but why didn't the legislature enact this statute? basically put all the private schools out of business, right? Why they enact the statute?
Well, these, I guess, religion motives.
Ooh, give me a little bit more. I think you're on the right track.
So a lot of private schools are religious in nature.
There it is, Catholic, yeah. So this is a aspect of our history that's not well remembered today. But there was a very strong anti-Catholic bias throughout much of American history. You'll see these political cartoons when John Kennedy was president that he was just like, this agent of the Pope, right? And that the Catholics are trying to destroy our country. Yeah, just pick your group, whichever the group happens to be at a given generation. There's stuff about it. This law was motivated in large part by anti-Catholic animus. This was designed to shut down Catholic schools. Now, there were military academies, right? There were private, non-religious institutions. But the leading private schools in this era were Catholic schools. It's no surprise that the leading plaintiff was the Society of Sisters, which was a group of nuns, right? So again, Austin, what did the court do? Justice Mcreynolds wrote the majority again. What did the court do then with this case?
They found the Oregon statute unconstitutional.
Please tell me why.
Well, they said, I think first that they said that it unreasonably interferes with the liberty of parents and guardians to allow their kids to be educated as they saw fit.
Austin, was this a case brought by parents challenging the fact that their school is closing down?
No, it was brought by the sisters, right?
Yeah, and it's not just as the corporation. I paused in this note very briefly for the notion that corporations have no rights. This is a fairly old doctrine. It's not new, right? You have corporations asserting the 14th Amendment. But it wasn't, again, the parents, it wasn't the kids. It was the teachers. It was the actual corporation itself, or the institution brought the suit. And this case follows very neatly from Meyer, right? If you have the right to direct the upbringing of your children, then also you have the right to send them, you have the right to tell them what school to go to. Now, the court doesn't say that laws regulating education are unconstitutional, right? The state can say that you must teach certain subjects, you have to have a minimum level of curricular reform, etc., but they can't shut down the institution altogether. Okay? All right, so any questions on Pierce and Meyer? So the jump from Pierce and Meyer to Buck is a very difficult one, right? Because you have these fairly mundane laws, right? Okay, fine. You can't teach foreign languages, okay. You can't have private schools, okay, that's bad. And then you go to Buck. And it's like, what the hell, right? And this reminds me a little bit of when you go from Yik Wo, for example, right? To then a couple years later, you got Plessy. And it's like, whoa, what just happened? I thought we were going one way. Strouder also, oh, you're going one way, then you kind of zig the other way, right? Buck v. Bell is a case that's not even in every case book. It wasn't in Randy's second edition. I made him add it because I think it's a very important case to understand that even in this era, this 1920s, where you applied a presumption of liberty, that presumption was not applied consistently. All right? So let me walk you through the facts of Buck, because the facts of the case aren't in the case. If any of you want to read more about this, there's a book called Imbeciles by a guy named Cohen. Very tough book to read, not just beach reading. This is a tough book, and it goes through the facts in great detail. But pick it up and let me know what you think. I read it about a year or two ago. So let me give you the facts. In the early 20th century, eugenics became a very well-accepted discipline of science. Right? You had major universities with departments on eugenics. You had professors at Harvard and others teaching this as science, the same way you would study chemistry or biology today. And the notion of eugenics was that you could use science to direct human evolution. right? So you had Darwin, who taught about survival of the fittest. And they said, okay, if you can have survival of the fittest, if you make sure only fit people reproduce. Now, this took itself in a lot of different shapes. So, for example, you might discourage some people to reproduce, and you might discourage other people from not reproducing. It's often thought that the Nazis in socialist Germany invented this, and it's simply not accurate. We did. It started here, and they took it to the next level, I suppose. So the law at issue in Virginia was passed in 1924, and I want to pause here. We'll do a case in a couple weeks called Loving against Virginia. Anyone see the Loving movie? Came out a couple years ago. Very good movie. Very. Usually I hate Supreme Court movies. This was a good one. Actually, it was very well done. It involved prohibitions on interracial marriage. Beautiful movie. Go watch if you can before class. It's on Google Play. It's on all the channels. Oh, is it Netflix now? Yeah, go pick it up on Netflix. It's good. So in 1924, Virginia enacted 2 laws. They enact the Sterilization Act, and they enact the Racial Integrity Act. That was one issue in Loving. So the same legislature enacts a law that bans interracial marriage and that mandates compulsory sterilization. Why? The same motivation. They want to prevent undesirables from reproducing. So they first ban interracial marriage, thereby banning interracial children. And they say that if you are an imbecile, we will forcibly remove your ability to reproduce. Both laws were aimed at the same direction, keeping the race lines free of impurities. Right? Just understand they're from the same stock, these 2 laws. At the time, though, there was a question of whether these laws were constitutional. In fact, many state Supreme Courts, state courts, under their state constitutions, found that eugenic laws were unconstitutional. Right? So even though the case in the Supreme Court was 8-1, there were judges in states at the same time who were just as smart as Justice Holmes, right, just as well read, who found under their state constitutions that eugenic laws were unconstitutional. So there was a serious concern that if the Supreme Court ruled against eugenics, that this entire platform would fall apart. So individuals in Virginia engineered a test case. Right? They decided that we need a case to go upstairs to the Supreme Court to uphold, once and for all, the power of the state to have these sterilization laws. And for one reason or the other, and I can give you a few reasons why, they selected Carrie Buck. Well, this is Dr. Bell. He was the superintendent. Okay. Now, why did they pick Carrie Buck? And this is going to be a little rough, but I'll try and do as carefully. Yes, sir. That was part of it, actually. That was actually part of it. They wanted to show that this would affect everyone. Yeah, I think that there was definitely a racial component here, right? That if you could uphold this for a white woman, then it's good. Yeah, I think that's actually part of the case. But why Carrie Buck of all the white men in Virginia? Let me make it a little more precise, right? She had a unique family history that was relevant to the eugenics project, right? The purpose of eugenics is the reason why we have crime, poverty, whatever, is because people reproduce and they put bad stuff into the gene pool. Right? That's the reason why we have bad things in society. And if we can just prevent these imbeciles, I can't even say the word, imbeciles, from reproducing, we'll have a pure gene pool, right? So no interracial marriage, right? Keep the races separate, segregated. They can't reproduce, and we'll keep all the gene pools clean. So had they find out that she wasn't of this sort, they took a look at her family tree. And I swear I'm not making this up. This is actually in the case. They took a look at her mother Emma. So this is Carrie Buck, and that's Emma Buck. And they made this family tree, which I think it's in your book now, right? Yeah, I had to find the royalties for this, but I got it in your book, which I think is important. And they said, we have a family that's full of imbeciles. By the way, imbeciles doesn't mean what you think, right? It doesn't mean you're mentally handicapped, that you have a low IQ. It just means you're deemed undesirable. And frankly, what it meant here was promiscuous. That's what it meant. It meant promiscuous. So you have Emma Buck, you have Carrie Buck, and you have Vivian Buck. See the little F? I know it's hard to read, but it's in your book. There's an F in each of the circles. That stands for feeble-minded imbecile. So why was Emma Buck feeble-minded? Apparently she contracted syphilis. Okay, happens to the best of us, I suppose. No, just kidding. My point is, there were no antibiotics back then. It wasn't a thing, right? So they basically found some sort of mundane, condition was that she's promiscuous because she contracted an STI, right? So she's feeble-minded. And she gave birth out of wedlock. She wasn't married. Therefore, she's feeble-minded. We don't know where he is. He's not. See the question mark here? Literally, he's a question mark. Question mark, question mark. We don't know who these people's partners were. Good point. Thank you. And then we go down to Carrie Buck. This is, I think, is the saddest one of them all. She was basically raised by step-parents. And according to all accounts that I've read, and I think these are credible, she was raped by her stepfather. And he impregnated her. And she gave her birth at wedlock. And they charged she was promiscuous for that reason. And her uncle / husband, I don't know, her rapist, handed her over to this institution when she got pregnant. Right? So he handed her over to this thing saying she's promiscuous when he was the one who got her pregnant. Then she gave birth at wedlock as well to Vivian, the third on this list. Now, at the time, Vivian was a couple months old. And they need to show that she was an imbecile also. So they administered her an intelligence test. And I swear, I'm not making this up. I read that book, Imbecile. I couldn't believe when I read this. There's a picture of her somewhere in here. I can't find it now. Okay, sorry. They gave her an intelligence test. And I swear, for a little baby, they took a coin. And they sort of went like this in front of the face. And she said, her eyes aren't moving for the coin. She was sleeping. I don't know. We don't know if the test was even done, so I can't even tell it's real. But this was her mental test. Therefore, you have 1, 2, 3 generations. And this led to the most, one of the most, I don't know, the most awful, in the top 10, one of the probably top 10 most awful sentences in Supreme Court opinion. You guys read a lot this year, not number 1, but the top 10, that 3 generations of imbeciles are enough. And I didn't understand that line until I found the family tree. I was like, oh, that's what he was saying, right? It wasn't obvious from the opinion, but it's like, oh, that's what he's talking about. Now, that's it.
Well, why was he using that language? Like, I understand that he said...
I'm going to get there. I promise.
Oh, okay.
But the doctors made all this BS up, right? They deliberately withheld the facts from the court because they wanted to get a test case at the Supreme Court. And it gets worse because the lawyer assigned to Carrie Buck under this procedure worked for the colony. The lawyer assigned to Carrie Buck worked for the group trying to sterilize her. He didn't call a single witness. Didn't put any evidence in. And this part is a little bit less clear, but it's not clear Carrie Buck knew what was going on. Okay, she wasn't an idiot, right? She graduated high school. She went to high school, and then she graduated, but she could read and write. In fact, one of the pieces of evidence they put forward that she was promiscuous was that she wrote flirty notes to another boy in high school. That was evidence she was an imbecile. She was right. She was literate. She wasn't. She was literate. But that was actually in the record, that she wrote flirty, promiscuous notes. By the way, Vivian went on to be a fairly good student in school. I found a report card somewhere. She got B's. But then she died when she was quite young. Some sort of intestinal disease. Yeah, sad, the entire family's sad.
They poisoned her?
I'm sorry?
They poisoned her?
I don't know. I don't think so. I don't know.
Well, because she was getting A's and B's.
To disprove their grant thesis. At this point, they didn't care. Carrie Buck was very sterilized at this point. But it's not clear that Carrie Buck knew what was going on. And this is actually true. A lot of women were sterilized under false pretenses. They were told that they had some sort of hip condition and needed to have pressure relieved. And a lot of them were just getting surgery without telling them what it was. And in fact, apparently Carrie Buck didn't know what was going on because she didn't really go to these proceedings. And she found out much later what they were doing to her. She didn't really even know this entire thing was going on. She was this massive case, and like her lawyer was like, whatever. So there's a lot of ways you can approach this case, and I don't ever know which way the correct way is, but that works. I was going to say due process, but yeah, shame is good. Thank you. But let's start with the basics, right? We know that the 14th Amendment says that you can't deprive someone of the liberty without due process of law. At a minimum, you need some sort of fair process, right? This is a lottery. Are we just going to throwing stones at someone, kill them to death, right? The court here seems convinced that the trial was fair and that the process was fair. It wasn't. So even if you don't think the word liberty has any meaning, on procedural grounds, this case could have come out the other way, right? Procedural grounds. But it didn't. And Justice Holmes basically says, we're not, the procedure is fine, so there's a challenge to the substance of the law. He says that very clearly, I think. So then the court says, is there actually a liberty interest in having your reproductive organs functional? Now again, this isn't the modern day case, is the right to an abortion or contraception. This is, can the state come in there with a scalpel and remove your fallopian tubes? Right? This is not about whether a private provider can do something. It's whether the state can lock you up, put you in a gurney, and sterilize you. Okay? Now, the court seems to acknowledge that, yes, this right exists, but the means are justified by the ends. And this is where I think to Mia's question a minute ago, Holmes was a social Darwinist, without any question. He was. He believed that this was a correct decision. That morally, he believed this was correct. He believed that firmly. And read his letters, his correspondences. And he firmly believed that the state should remove these people from reproductive ability. Right? And the reason why I used such inflammatory language, to Mia's point, was he wanted to make his point to some of his colleagues that this was something very good to happen. So when he says that 3 generations of imbeciles are enough, which is unnecessary, you don't need to say that, he believed it. And he thought that the compelling justification was to rid these people from this population pool, get rid of them. And if you have a judge who makes a judgment that, yes, this interest is compelling, and the means then are sufficient to justify those ends. And that's Buck v. Bell in a fairly brief order. Right? And he makes, yeah, Jesse, please.
I just have a quick question.
Yeah.
So in this case then, are they saying that you have to show that the person being sterilized is a 3rd generation feeble-minded individual?
Well, she was second. She was 2nd generation.
Okay, so it doesn't matter.
But they want to show that she's already reproduced, and we just stop her from reproducing a second time.
Okay.
Right? The idea is, she already reproduced once, we have to stop it from happening again.
There are like age limits or something, what stopped them from not, Vivian died, at 8? But at some point would they have come back
Maybe.
for her?
Maybe. Yeah, this is maybe why they poisoned her. Right? No one's ever said that before. That's actually a good thing. Yeah, but over the decades, they sterilized people of all ages, all from basically up to the age of fertility, whenever someone's fertile. But the point I want you to convey is this, right? Go back to our polling question for the day. Justice Holmes draws this analogy. Now, Justice Holmes, you can hate on him, and it's fine. I don't mind, right? But he had an amazing life. He lived as a Civil War veteran. And he was injured twice in war and survived twice. Right? And back then, you didn't survive gunshots, you died. And he was actually shot twice and survived both times. So he had a remarkable, life. And he gets to the court, one second. And he became, how do I put it, very cynical of everything. And he says, he makes this point from personal experience, if the state can call on you to give your life in war, why can't they do something far less than sterilize you? Or if the state can lock you up for life, why should they can't do the lesser thing? Or if they can execute, I'm reading a quote, your degenerate offspring, why can't they stop the offspring from happening in the first place? And for him, it's all about the ends and the means, right? If they can do all these much bigger things, what's the big deal of this single procedure? And for him, it's such a trivial intrusion on liberty that the state's interest justifies it. Kanisha, patiently waiting.
So the interesting thing is the court. You said the court says that they would lock people up until they were no longer friends at some age. If you think about that in respect to property, so property says, property law says that you are able to have offspring when you do the whole rules of perpetuity.
Fertile octogenarian, right?
You're fertile till the day you die.
Yes, ma'am.
So this the same court, right? Ish, maybe not the same people, but the same conceptualism.
Well, then I guess you lock someone for. Then you lock them for life, then.
So it's just weird how it always seems like the court twists concepts to make them fit. So for property, you can say, well, yeah, it's forever because that works with what they want. But for this,
you know what?
Fertile at what? What's the age? Because a man,
the precocious toddler,
have a baby until he dies, literally. So do you lock the men up forever and then you don't? So then you got a sexist issue.
Yeah, so then you lock them up for life indefinitely.
And
they
then
can always
women, you let them out at 50, 60. I mean, so it's just weird the way that the court is not very stable.
No one's ever brought up the fertile octogenarian in Buck v. Bell, but I'm grateful. That's actually a very good point. Thank you. That's a very good point. I'll remember the next time I teach Buck v. Bell and do rule against perpetuities. Did you like to rule against perpetuities?
Oh, it's great. Yeah, we're
Still in it right now.
Oh, I don't test. I do it in one class and I move on. I get over it.
Oh no, it's like several books.
You don't need it. You don't need it. All right. It will not be on your bar. All right. What else in Buck v. Bell? I went through a lot, but I'm sure I skipped over stuff. There's only one dissenting vote by Justice Butler. And if you notice, he didn't write a dissent. And that's significant, right? And I want to just dwell on this point for a minute. You're reading Buck v. Bell and you're going, oh my God, this Holmes guy is insane. What am I reading? What is this crap, right? It's like, where's the dissent? Oh, there's one, right? When there's a decision in the Supreme Court and there's not a dissent for someone to call out the majority on whatever stuff they're doing, it matters. And I can give you a couple examples. So we had a Bradwell, right? This was the woman who wanted to become an attorney. Justice Chase was very ill at that time, and he wrote just a one sentence, I dissent. He didn't write an opinion. So all you have is a majority saying all these things about women, but no one's responding to them. And I think this case is in a similar boat. It's not like with Pless, you got Harlan, right, writing off, or civil rights cases. This is, or even Dred Scott, you have dissents. This is at a time in the 1920s when it's decided not one member of the court decided to write something in opposition to it. Even though you had state Supreme Court judges who were just as smart, who wrote opinions striking down these laws. So I think that's actually a significant fact. Why did Justice Butler not write an opinion? I've looked into this. I can't find a good answer. He was the Catholic. There was actually, for a number of years, there was one Catholic seat in the court, right? They'd have one Catholic justice. We have four practicing Catholics, 5 by birth, on the court right now, which is fairly anomalous. But for years, there was one Catholic seat and there's one Jewish seat. That's how it was in the court. And so he was the Catholic justice, and the Catholic Church was very much opposed to sterilization. The rumor is that's why he dissented. I can't find any evidence that's true, just he didn't really discuss it. So we have only the majority opinion. And one second, Mia. And after Buck v. Bell, the floodgates were opened, right? Floodgates were open. State after state adopted this. By the 1930s, almost more than half the states in the Union had these sorts of laws in the books. And I had a student a couple years ago who said she had an aunt in Puerto Rico that had this happen during the 70s. So, I mean, it went on for a very, very, very long time. One note, is Buck v. Bell still good law? The answer is yes. It's still cited. You actually have cases where prisoners are sometimes given a choice. You can stay in jail or have castration. So this is actually somewhat common. Let's say you have a sex offender, a guy, and you give him a choice. You can spend more time in prison or you can have what's called chemical castration. What?
That's not fair. Yeah. So that's the same thing, because that's where you have someone who is like a child molester, sex offender, or whatever. They probably need to be castrated, and that's a choice. That's to say you did something and your punishment fits the crime, because clearly that's what they use the crime, right? So that punishment of means fits the ends, and that's the choice that they get to make. These are people who decided that you're an idiot or promiscuous or whatever.
Guys, just one at a time, please. Yeah.
That's not even the same thing.
My only point was it's still cited. The case is still cited. I agree with every word you said. But yeah, Mia?
I had a different question.
Sure.
He kind of talks about like the equal application of the laws. He says that I think it fails when, like, I don't know who he's responding to, this phantom person, I guess, in their discussions about like the argument that even if it applies generally, or maybe that's what was raised, it fails when combined to the small number of people who are in institutions and not to the multitudes that apply. Is that, they've discussed later on about like the doctrinaire requirement, like the applying to like one class instead of like all the classes?
I'm not sure I understand your question. I'm sorry.
Because he talks about if the law doesn't have to be applied to everyone.
Oh, I see. Okay, now I understand your question. So okay, yeah. So one aspect of this law is that the only people who are subject to sterilization were those in the colony. People outside the colony who are perhaps imbeciles were not subject to this law. So the argument is, how come you're only focusing on people who are committed? And Holmes says there's no obligation to have any sort of equal enforcement, that the state can pick and choose who they want to apply this law to, which is a very definition of not equal protection of the law.
What was that? Was it Mueller? Which one was the one where the women had the thin blood?
Mueller.
So is that just kind of a perpetuation of that they continue to carry through when they start talking about in later cases like West Coast, where there is no doctrinaire requirement that
the law? Yeah, I mean, so generally when you're applying the sort of Holmes presumption of constitutionality, the government can pick and choose how they proceed, right? They can decide that we'll start by limiting sterilization to this colony, and maybe we'll expand it in the future to other groups, right? That they're not obligated to make a foolproof solution at the outset. They can move incrementally, as it's often said. Chris? Oh, yeah. Was your hand up?
Yeah, sorry. Well, this was just kind of like an off-topic thought
Please.
I was having. But are we going to see Buck v. Bell and Roe v. Wade? Is this along the lines of this?
Buck v. Bell is favorably cited in Roe.
I've heard that, but I didn't know.
It is.
I'm guessing we'll talk about that.
Yeah, so it's in the case book. I had added it. So there's a passage, and I'll just jump ahead, but there's a passage in Roe where Justice Blackman's no relation, but Justice Harry Blackman is discussing does a woman have a right to choose what to do with her body? He says no, she does not. He cites Buck v. Bell. Yeah,
So
Janice.
let me ask you, can you go back a little bit, okay? Because
Please.
Is Holmes using the presumption, the irrebuttable presumption of constitutionality here? Because it seems like he's making more of a moral argument than he's making a constitutional
He's a believer. Yeah, he's applying, I think, an irrebuttable presumption of constitutionality because no amount of crying by Carrie Buck could ever change his mind, right? Because he's of the mind that the state has a compelling interest to do this, and so the ends are justified.
Okay.
Because, in other words, if this law is not enough to make you second guess the state,
Nothing more.
nothing will. And he knew the facts, right? he knew the 3-generation bit, right? He understood that from the record. He read the record. He said that, look, there was no evidence presented at trial, right? It wasn't like this was a mystery. Anyone looked at the record in this case would know right away that this was not a real trial. But he said, it doesn't matter, we're going to defer. Right? It shouldn't be the government's job to put on a full trial that's, he might even not have required a trial. I think he probably was done without a trial. Yeah, tough case. Not a good. Yeah, Mia,
Is that what the irrebuttable presumption gets to?
It doesn't matter.
Like
It's
where-
different. If the legislature adopts this law, that's enough for him.
And then the court adopted that, like the Marshall Court, Warren Court adopted that?
Well, they adopted it in the economic context, right? And this is a split that's worth mentioning now. In the early 1920s, the court didn't really distinguish between due process cases on personal liberty, autonomy, bodily integrity, and economic liberty. That distinction didn't really exist, right? Because Myers and Pierce were about corporations having rights to teach. It's sort of blended. But by the time you get to the 1930s and 40s, the court starts treating things differently. And you get to Lee Optical, they split it very clearly. Yeah?
But if you have a theory that says that if the legislation makes a law, then it doesn't matter, what is the point of having this separation, right? So you're saying nobody's checking, there's no check, there's no balance.
Nope.
Then what is the purpose of the judicial system at that point? You just let the states do whatever they want. You don't need them.
But the key point is we're dealing with an unenumerated right. It's not like free speech, which you tell what free speech is. The word liberty is not defined. And what Holmes would tell you if you asked him is he'd say, I don't know what liberty is, but that's for the legislature to decide. It's not my job. Right? And that's the key point. It's not that the courts piece out for the entire project of judicial review. They review other stuff, but not for the unenumerated doctrine of substantive due process. Right? That's a doctrine unto itself. Right? A lot of lawyers today and judges reject the idea of substantive due process altogether. They say that due process only means procedural. Right? There is no, courts can't decide. Right? Think of, go back to Dred Scott, right? That there's a right to own the slave. Right? A lot of conservatives will draw a line from Dred Scott to Roe, and they'll say that courts should not be in the business of assigning means toward liberty, the due process clause. If you take that position, then what about Buck v. Bell? And at that point, all you could say is, well, the procedure wasn't fair. But what if Carrie Buck was given a competent lawyer, right? Let's say Carrie Buck was given a real lawyer, and the lawyer had to prove she wasn't an imbecile. And the judge says, you know what? I find she's promiscuous. She was not an imbecile. Fair process. She had a good trial. Is the law still unconstitutional? That's where the lottery comes into play. That no matter how much process you're given, some deprivation of the right are still not justified. Okay. So any other questions on Buck against Bell? Okay, let's go back to our timeline, right? So let me bring you up to the 1930s at least, right? Lochner and Atkins, no longer good law, right? After the New Deal, we'll get there in a minute, the court started drawing distinction between economic liberty and personal liberty. So all the cases involving economic liberty are not good law anymore, like Atkins. What about Myers and Pierce? Good law. And later cases said, well, those are really religious freedom or free speech cases. So you'll still see Meyer and Pierce favorably cited. So they're still good law today. What about Mueller? This was the laundry case, right? Well, it doesn't get cited for what it actually says, but it says the state has a power to protect the welfare of workers, even if it was based on thin blood and all this other stuff. What about Buchanan v. Worley? This was the zoning case in Louisville. That's still good law, but it's generally viewed as an equal protection case, but segregation, not an economic liberty case. And Buck v. Bell has never been overruled, and it remains good law, and it's been favorably cited fairly recently in lots of cases. It's still cited. Go run a key site. Shepherd that later. Just if you don't believe me, just run a key site.
How could you cite that as a pro case for anything?
Look, it's cited. It's cited.
Believe you.
Kyle.
I assume that forcible sterilization is no longer good law.
Well, what kind of process predates it, though? So, I mean, not that it's analogous, but there are cases where people are given choices to be released from prison earlier or be castrated. So I guess that's not compulsory in the same sense of Carrie Buck, but the state still does this. And let's just put it this way. It's not always clear that the doctors involved give full disclosure to the patients. Right? They may not fully understand what's going on. There's litigation over this. So eugenics hasn't gone away. It still exists. And there's still a lot of people who believe that certain people should be castrated, so that they shouldn't reproduce. Not because of genetic indesirability, but strain on welfare.
Yeah.
It's shifted to a different venue, but the sentiment still exists. That certain people should not be in the gene pool. Yeah.
So this is outrageous, but do you think it would be constitutional to, let's say, for the state to execute people over a certain age because there is a strain on the Social Security system and whatnot?
I think I had an exam question along those lines once. Right. So I mean, let me just use Holmes's logic, right? If the state can draft people and send them to war where they're going to die, why not just have a law that says after a certain age we just put you out of your misery and reduce the strain on the nation? Science says we are overpopulating and we're running out of food and we need to have a survival of the younger to reproduce.
Because the people that are making those laws are old.
They'll never write that law. Congress is exempted. Congress will be exempted. Marcus?
Distinction could be drawn between actually pulling a trigger or setting someone up to be killed by.
Put him on an iceberg, drift to sea, right?
So they don't have the executing.
Guys, just one at a time, Yeah, Kyle?
Oh, I was just wanting to clarify the execution doesn't have to be by bullet.
Starve them to death, just deprive them of food.
Just push them off a mountain.
So,
Based on what you're saying, and this,
Yeah,
this
Janice?
is still good law, right? Based on your scenario, that can definitely, under
If the-
Holmes's approach, given deference to the legislature, that can definitely happen. It's almost the same argument.
if the interest is compelling enough, yeah.
Yeah.
But you said, because I asked about the footnote 4 as far as like voting, because you said the ballot box is what imposes the limitation on the legislature.
Well, Holmes doesn't even believe that. There are other cases where he upholds, grandfather clauses. He doesn't actually believe that. But yeah.
So, one of the footnote 4 exceptions was like if it affected how like the officials got elected, wouldn't that also include voting rights things? So, and you said that would still control over in the Holmes scenario.
Well, you're a little bit anachronistic. Holmes came before footnote 4, so you're trying to work backwards a little bit. Holmes upheld grandfather clause and vast disenfranchisement, so I don't think it really mattered to him. I think Holmes would say when you have an unenumerated right, the legislature prevails because they're the legislature.
Okay.
In other words, the majority can rule because it's the majority.
For unenumerated.
And probably some enumerated rights also. He came around to free speech later in his career, but he was very dodgy. All right, other questions on Buck? All right, this is the next case. And I apologize, I'm lecturing more than you usually do because I have a lot to get through today and I have to move quicker than I'd like, so I apologize. Not that you care. But you'll poor Brooke's been on deck for like 20 minutes already. Hi, go ahead. I'm sorry. Do you want me to call on you? Do you want me to call on you?
No, I mean,
Okay.
whatever. I'll go.
You'll get there eventually. I'll get you. Okay, well. So the next case is West Coast Hotel v. Parish. And the case involves a minimum wage law in Washington State. Now, wait a minute. Didn't we already do a case like this? Didn't we do like 3 cases like this, right? Didn't the Supreme Court already hold in Atkins that these sort of wage laws are unconstitutional? Then why the heck did Washington enact a law that was unconstitutional? They didn't care. Right? They didn't care. They enacted a law that they knew went against the Supreme Court's decision in Atkins because they wanted to challenge it. You ever think of a test case where they basically engineer a case, right? They just passed a law that was unconstitutional according to the court. Now, the upshot is, and long story short, the Supreme Court upheld the constitutionality of the Washington labor law, and they expressly overruled the Atkins case. Why they did it is far more important than what they did. So let me tell you the conventional narrative. This is what I learned in law school. It's not correct. I regret, not that I regret learning it, but we know better now. The conventional narrative was this, that throughout the 1920s and 30s, the court was fairly conservative. And then after Roosevelt came into office in 1932, the Supreme Court started striking down his progressive legislation at the state and also federal level. And you had this conservative bloc on the court. So you had the four horsemen, they were called, the four horsemen of the apocalypse. You had Justice Mcreynolds, Justice Butler, Justice Sutherland, and Justice Vandevanter. Yeah, Mcreynolds, Butler, Sutherland, and Vandevanter. These are the four conservatives in the court. And they found all this legislation to violate the Due Process Clause at the state level, or it exceeded Congress's commerce powers. Don't forget, we did the New Deal already in commerce stuff, right? It happens as well here. So what happens? You have these conservative judges voting together as a four-member block, and then you had a fifth member, sometimes, named Owen Roberts. Not John Roberts, Owen Roberts. Owen Roberts was appointed by President Hoover, and he's often described as conservative, but I think he was more moderate, sort of in the middle. And sometimes he would vote with the liberals to uphold legislation, and sometimes he'd vote with the conservatives to hold this legislation unconstitutional. But then we get to West Coast Hotel v. Parrish. Okay? It's argued in 1936. Okay? After the case is argued, it goes into 1937, President Roosevelt announces his proposal. Very timely, right? He has an idea. He says, we need to add more justices to the Supreme Court. For every justice over the age of 70, we'll get to nominate a new member to the court. Now, he made up some excuse saying, oh, the justices are tired and overworked. We need to reduce the workload. BS, right? That wasn't the reason, right? His approach was fairly straightforward. He said, the court's ruling against my stuff. The way to beat that is to add more judges who will support my stuff. There's no way of looking at it, right? He could have amended the Constitution to change, for example, expand the Commerce Clause, right? He could have done that. But he said it's easier just to appoint new judges. The proposal was very unpopular. And in fact, members of Roosevelt's own party said this is nuts. You can't change the court like this. Number 9 is not fixed, but it's been a tradition. And by adding new members, you're going to disrupt judicial independence, and this is very bad. So Roosevelt's proposal sort of stalled in Congress. But after the proposal was made, West Coast Hotel came out. And Justice Owen Roberts voted with the liberal wing of the court to uphold the Washington law and overrule Atkins. So everyone said, oh my God, his plan worked, Roosevelt, right? The mere threat of packing the court was enough to get Justice Roberts to change his vote. And that Justice Roberts changed his vote to uphold the legislation. And people call this the switch in time that saved 9. The switch in time that saved 9. Why? There's an expression that says the stitch in time that saves 9. Right? I'm sorry, damn it. The stitch in time that saved... Yeah, I said right. Yeah, the stitch in time that saves 9, right? That if you sew a sock now, you'll prevent it from having a hole later, right? It's about mending stuff. Anyway, it's a whimsical, aphorism. The only problem with this story is that it's not true. And we know this because we have what are called docket books, right? These were books kept by the judges in the court where they recorded how people voted at conference. And we know that Justice Roberts cast his vote to uphold the Washington law before the Roosevelt proposal. He didn't change his vote. So this entire theory, which many people still report as being true, that Justice Roberts changed his vote. Whoever heard that before? That Justice Roberts changed his vote. I had a chapter in a book called The Switch in Time That Saved Nine, right? That Owen Roberts changed his vote in response to Roosevelt. It's not accurate. Now, to John Roberts change his vote in response to President Obama, I don't know. We'll leave that for another day. When I get their papers. Once Justice Ginsburg retires, we'll get all of her papers. I'll learn everything. It's going to be a lot to read. Up first. Once Justice Ginsburg retires, I've heard all of her papers are coming out, so we'll read everything that happened. Apparently, I know this from clerks, she's told people that, so there's a practice among the judges that they won't release their papers for a very long time. So Justice Souter is the worst. He said he won't release his papers until 50 years after he dies.
Will they decide?
They get to decide. He's like in his 70s, he's very healthy. So I might be like 100 by the time his papers actually come out. I made a pact with a friend to actually go visit them when we're 90s. Basically, it'll be another 50 or 60 years when the papers come out. Justice Thurgood Marshall does something different. He has papers available immediately. Everything, wide open. And the problem was, he had stuff on pending cases that came out. So you had all these reporters going to the Library of Congress reading about pending cases. It was a disaster. So after that, I think Justice Rehnquist made a plan that says we will only release papers after all the judges who were on the court at that time are dead. So for example, Justice Stevens is still alive. He was put in the court in 1977. So once he passes away, a lot of new papers will be released up until the point when Justice O'Connor joined the court. When she passes away, up until the point that Justice Scalia passed away also, so Justice Kennedy passed away. So it's incremental. So Ginsburg apparently is doing the Thurgood Marshall rule, saying screw it. So we'll get our papers eventually. But going back to West Coast Hotel, the court didn't change its mind. Roberts did not change his mind after Roosevelt, but people thought he did, which is why it's important. But after West Coast Hotel, going back to my fancy graph, the court established what we call a rebuttable presumption of constitutionality. What that means is that the court will presume legislation is constitutional, but you can still rebut it, right? That the person challenging it has to put in evidence that this law is improper. But they say economic legislation, like a minimum wage law or a maximum hour law, that's within the state's police power, and there's plenty of good reasons why. Once you apply a presumption of constitutionality, all the economic laws start being upheld, and that's the end of the story.
Well, so you're saying
Yeah, Monique, go ahead.
You're saying that a presumption of constitutionality lets, if you're talking about economics, no matter what, it's gonna be fine. You can present evidence, but it's gonna be, what were you saying?
I'll try it again. Thank you. Thank you. In the 1930s, the court didn't distinguish between economic rights and personal rights. You don't get that to the 1960s with the contraception cases and the abortion cases. So I'm somewhat speaking out of chronology by discussing personal versus economic. But here, you only have an economic presumption, you only have a presumption of constitutionality for the entire due process clause, right? All laws reviewed under the due process clause after West Coast Hotel get the presumption of constitutionality. You can rebut it, but it's really hard. But you can still rebut it in theory by giving evidence of why this law is improper. That changes if you go back to the 1950s with Lee Optical. Once you get to Lee Optical, it doesn't matter, right? You do whatever the hell you want, the government's going to win. That's full Holmes, right? Because think of even Justice Harlan, right? Justice Harlan voted to uphold the law in Lochner, right? But he struck down the law, for example, in Buchanan, right? So that there's some laws that might, actually wasn't in the court then, but his approach would struck down the law in Buchanan, right? You can have laws that are unconstitutional. Let me go back to my chart. It makes more sense when you see them all up on one plot, right? So with presumption of liberty, you can pick and choose. You can have a presumption of liberty. But the Harlan approach would say, we're going to uphold it unless you have evidence to the contrary. And that's presumption of constitutionality. Okay? Thank you. If it's ever not clear, raise your hand. I always try to be as clear as I can, and for all the people watching at home. All right. So any questions in West Coast Hotel, if you parish? Sorry, was the hand? I didn't see any.
You didn't do it, Ken.
I did it.
Presumption, rebuttable presumption of constitutionality.
I did it. Do you want to do more?
No, okay. I thought, because when you started off, you said, let me give you the
Washington enacted a law
Got it.
that imposed a minimum wage. The court upheld it. The facts of West Coast Hotel aren't very important. What's important is that the court shifted its approach to the case law.
Should have put that in.
I'm sorry?
Never.
Put in what?
Before.
You can read lightly.
Could have read it differently. Go ahead.
Well,
Oh my God.
you're better off for it. I appreciate people who read carefully. By the way, the reason why you have to read carefully is the sort of stuff I test you on isn't like what I'm talking about here. It's going to be the nuances of the case. So you got to know this stuff. If the midterm showed you that, you know you have to have very small nuances to get a question. Yeah, Marcus.
And that economic condition was the right to
Yes. Yeah, the right of women to negotiate whatever hours they want, perhaps below the minimum wage. Okay, any other questions on West Coast? So Atkins is now officially overruled, no longer good law. All right, the next case is a very important case, but it's a strange case, right? United States versus Caroline Products. So the first thing that should jump at you is the name of the case, United States. This was not a due process case under the 14th Amendment. It was actually a Commerce Clause challenge. Then why the heck have I signed it in this unit? The reason why Caroline Products became so famous is not because of the facts of the case. The facts of the case are great. I love the facts of this case. But the reason why this case became so famous was because of a footnote, a very long footnote, the fourth footnote of Caroline Products. Now, when you're writing briefs for a court, do not bury important stuff in a footnote. If it's very important, put it above the line. But the Supreme Court, they dumped this thing in the footnote. It's like a page and a half long. It stretches across 2 pages, right? Why was this important? So when you get to the 1930s and you have West Coast Hotel, the judges already recognized that they had a problem, right? They recognize that if we say we're like Justice Holmes and any law that passes the democratic process upheld, the courts don't have much to do. This is Kenesha's point from a few minutes ago, right? They started to recognize that, wait a minute, let's not get ourselves in a box here, right? Let's not remove ourselves from the business of judicial review. Because if we do this, there might be some laws that we don't like, right? There might be some laws that we probably shouldn't uphold. So Justice Stone, who is a former law professor at Columbia, never law professor in the Supreme Court's a bad idea, writes this long footnote, right? Footnote 4 of Caroline Products. And I have the text of it up here, and I separated it into paragraphs, right? So the majority opinion in Caroline Products applies a presumption of constitutionality, Harlan style, right? It's rebuttable. They say that if you can give enough evidence to show that the Filled Milk Act was unconstitutional, the court will strike it down. Right? It's a rebuttable presumption of constitutionality. However, the body of the body of the opinion needs to be separated from the footnote 4. Because the footnote 4 qualifies the majority, right? In the normal case, we apply the presumption of constitutionality. However, there's an exit ramp, right? Where we don't apply the presumption of constitutionality if these circumstances apply. And there are several circumstances in these 3 paragraphs. Now, I want you to understand something. Footnote 4 is not a rule. It's not even a holding. There are only 4 members in the court who joined it, right? And the court has never consistently applied it, right? The court's never said, we are striking this law down because footnote 4. That doesn't happen. Instead, what the court says is, because of footnote 4, we will look at this perhaps with heightened scrutiny, a little bit more rigorous review. So don't think you can just say in an exam or in a brief, footnote 4, we win, right? It's more of a philosophy than an actual rule, right? This is not like the direct effects test or substantial effects, whatever, right? It's used in much more loose fashion. But I want to walk you through the 3 paragraphs of footnote 4, one at a time. All right, so I have the first one up here. This is paragraph 1. Okay, it says, the court should not apply a presumption of constitutionality when reviewing legislation that appears on its face to violate a specific prohibition of the Constitution. That is, the first 10 amendments of the Constitution. Freedom of speech, for example. Why is this important? When you're dealing with the Bill of Rights, there's no question of what liberty means, right? It's enumerated. Judges aren't in the same sort of wilderness trying to figure out, well, this is liberty and that's liberty. If you have something in the Bill of Rights, you don't apply the presumption of constitutionality. And just the wording I know sucks, but it says there's a narrower scope for the operation of the presumption of constitutionality. Let me say this more easily. You don't apply it, right? You don't apply the presumption of constitutionality when you have something in the Bill of Rights on its face, right? The law infringes free speech. We're going to learn later this is known as strict scrutiny, right? When you have something that restricts the Bill of Rights, minus the Second Amendment, you apply strict scrutiny. There's no presumption of constitutionality. The first paragraph, footnote 4, is not very controversial. I don't think most people disagree with it. It's pretty straightforward. Okay? Let's move to the second. Any questions in the first paragraph? Let's go into the second paragraph. The second one is far more consequential because it addresses the ballot box issue we've discussed a few times in class today. It says that you might apply, quote, more exacting judicial scrutiny. What does that mean? You look at the law more carefully, right? You don't just defer straight up. You want a tighter fit between the means and the ends. Right? Think of it as a difference between looking at a law with like a magnifying glass and a microscope. When you look at something with a microscope, you see a lot more flaws. If you're just looking with a magnifying glass, Justice Holmes looks at it with a blindfold, right? He just closes his eyes. But the different types of scrutiny is how close you're looking at it. Is it just reading glasses, a magnifying glass, microscope, electron microscope, right? How close you're looking at it. So there might be situations where there's a more exacting scrutiny when you have legislation that restricts the political processes which can ordinarily be expected to bring about the repeal of undesirable restrictions. In other words, usually when you have a bad law, the electorate can change it, but if the people can't change it through the electorate, that process breaks down. So he lists restrictions on the right to vote, restraints on the dissemination of information, interference with political organizations, prohibition of peaceable assembly, right? Generally, the court will trust the legislature to act in the public good. But judges should be more skeptical when the legislature seeks to change the rules by which they are elected. Because if they can change the rules by which they're elected, then bad legislation will not be repealed. This is often called representation reinforcement. This is a funny word. But it means that the courts can reinforce how people are represented in the electoral process. But again, the courts aren't going to strike down, for example, a voter ID law because it violates footnote 4. You're not going to see that. Right? People always want that. That's not how this works. It's a theory. It's not a rule that's actually applied. So any questions in the second paragraph? Second paragraph. Okay. Let's go into the third one. I can't fit all on screen, but I'll get most of it. Okay. In the third paragraph, the court identifies other circumstances where you might apply more exacting judicial scrutiny. Again, that means strict scrutiny or something approaching strict scrutiny. Right? If it affects religious or national or racial minorities. And he looks at Pierce v. Society of Sisters and Meyer v. Nebraska. Again, those were not religious liberty cases. They weren't. But the court is trying to recast them as religious liberty cases. They weren't. You know, the military academy wasn't religious at all. But then he speculates further that you might have a more searching judicial inquiry when statutes are directed at discrete and insular minorities. Why? Because prejudice against such groups tends to curtail the operation of political processes to protect minorities. So someone's going to ask me, Josh, what's the difference between paragraph 2 and 3? Not a lot. Paragraph 2 discusses reinforcing voting rights generally, and paragraph 3 discusses reinforcing voting rights with respect to discrete and insular minorities. They wind up in more or less, I think, the same place. But the big difference is there's a racial component. By the way, what does insular mean? Separated, right? They don't have access to the political channels, right? That they can't change the ballot box what might otherwise be bad legislation. So this is probably the most important footnote in Supreme Court history. I think it's up there. It's got to be in the top 5 at least. And it introduced an entire new theory of constitutional law. Okay? But for our purposes, it's important because it qualifies the presumption of constitutionality. Not all types of legislation are reviewed with deference. If a law violates the Bill of Rights, you give it heightened scrutiny. Economic liberty is not in the Bill of Rights. Right? This was a way of saying, okay, we're going to keep applying a presumption of constitutionality to like Lochner cases, but in other cases, we're not going to apply it. This is where you start to fork off between the economic liberties and other types of rights. Right? If it's in the Bill of Rights, now, who mentioned the Ninth Amendment before? Was that Mia? Ninth Amendment says the mere fact that a right is not enumerated doesn't mean you disparage it. Footnote 4 is in tension with the Ninth Amendment. Because what this says is we have heightened scrutiny to rights that are written down, but if the right is not written down, we basically can give it off to the side. Okay? So now going forward after footnote 4, rights are treated differently. If a right falls into one bucket, you get strict scrutiny. And if a right falls into a second bucket, you get basically a rational basis review, very deferential. Right? This began basically splitting rights in half. Rights that courts favored review strictly, and rights that were not favored were reviewed deferentially. And it's up to the judge to decide which bucket a right falls into. And we'll spend a lot of time the rest of the semester saying, well, where does the right to abortion fall, and the right to contraception, and right to sodomy, and right to marriage? Where do these rights fall? Is it fundamental? Is it not fundamental? That entire enterprise of distinguishing rights began with footnote 4 of Caroline Product. Okay? One at a time. Yeah. Yeah. Am I? Or maybe I know it was first. I wasn't listening. Yeah.
Question, yeah. I was just going to say, so economic is like its own bucket, basically?
Yeah, it's not in the Bill of Rights, so it goes into base. At this point, economic is still reviewed by Harlan, and eventually it's a Leoptical economics reviewed by Holmes. Am I?
Yes. So you say in the second bucket, I know that rights not fundamentals review what's deferentially.
Yeah.
How about rights that are fundamental? How is reviewed?
Rights reviewed that are fundamental are given what we call strict scrutiny. Right? They're viewed very skeptically with a microscope, not the magnifying glass.
Got it. Thank you.
Not a blindfold. Economic rights are given a blindfold. It's just whatever.
Fundamental rights, though, are the enumerated ones in the Bill of Rights?
No. If it's enumerated, it doesn't need to be fundamental because it's in there. When I say fundamental, I mean rights that are just not. It's where liberty. What does liberty mean, right? All this stuff about unenumerated rights.
So then what's fundamental?
We'll do fundamental later. But fundamental refers to certain unenumerated rights that are very important, that a court finds favored. Right? If it's enumerated Bill of Rights, it's easy. Right? That's the first paragraph. But there might be other rights that are also fundamental that are protected. Right? Look, go back to the first paragraph. So for example, it says, You don't apply the presumption of constitutionality when legislation appears to be within a specific prohibition, such as those in the first 10 amendments, such as but not limited to. So there might be other rights which are not in the first 10 amendments that are still protected because within the 14th. All right. So any other questions on footnote 4? Again, Caroline Products, great case, fun facts. Read the little footnote to footnote 4 afterwards. I love the story. But it introduced a new theory of constitutional law by which rights were basically split in half. If a right fell into one of those buckets, courts give it very strict scrutiny. Otherwise, the court gives it a deferential approach. So you're already seeing how the decision of a judge to label a right fundamental or not, or in this bucket or that bucket, is almost determining the outcome. Now, unless you can get a right, unless you can put a right in the correct bucket, the courts are going to uphold the law. So, any questions on Caroline Products? I'll do Lee Optical in the last 10 minutes. Move quick. I got to split this class up next year.
Okay, just to be clear, just a quick yes.
Please.
Okay, so we have fundamental rights, and they can be unenumerated, and we have non-fundamental rights, which are unenumerated, and then there's the Bill of Rights.
Yes.
Okay.
We will spend like 3 weeks on what a fundamental right is. I don't want to go too far into that today, because the court doesn't use that language here. I'm using it because I'm giving you modern language to describe what they're doing back in the 30s. But if you were, the word fundamental is not in this paragraph. You're not going to see it. Any other questions on Caroline? All right, so the last case, right? So by the time we get, let me show you my timeline. By the time we get to the 1930s and 40s and 50s, the court had more or less settled in they had a settlement, right? And they understood that it's not the role of the courts to second-guess legislatures unless you have one of these very narrow exceptions like in footnote 4. But they still applied a presumption of constitutionality that could be rebutted. And at the time, there were courts that said that certain economic regulations were not valid. And I gave you one of those. This was Lee Optical. Now, we gave you the district court opinion as well as the Supreme Court opinion for a reason. To show that even in the 1950s, you still had lower courts that applied a rebuttable presumption of constitutionality. So we have the facts on Lee Optical, right? Where the government said, you need to have a medical license in order to fit glasses, right? Now, fitting glasses is a very straightforward task. Use a device to measure the prescription and reproduce the lens. It didn't require any medical training. Why was this law enacted? I'll give you an easy reason: to protect doctors, right? To make sure that if you wanted to have an eyeglass, you had to pay a doctor on staff. Lee Optical was like a lens crafter, right? It was a national chain, and they just set up shop, and they didn't have to hire as many doctors. The district court said, there's no reason why you have this law other than protecting doctors, right? It doesn't protect health and safety. A lens technician, an optician, can do just as good of a job, right? They can do just as good of a job fitting these lenses. So it's not rational, right? That the fit between the means and the ends aren't close enough. That the government's concerned about safety, they can do this other ways, not the way they chose. That is what we call a rebuttable presumption of constitutionality. The lower court started with the presumption that this law was valid, but evidence put forward by Lee Optical rebutted that presumption. Everyone see how that works? But then we get to the Supreme Court, an opinion by Justice William O. Douglas, Roosevelt appointee. And in this case, the court changes course. They say, it doesn't really matter whether this law has any relationship to health and safety, because it could have a relationship to health and safety. In other words, it doesn't matter what the government's actual intent is here, because there could be a rational basis for it, right? Maybe the government could say, well, people need to get eye exams every year to keep their eyes safe. And this way, force people to go to a doctor more to get more eye exams. Is that the actual reason this law exists? Of course not, but it doesn't matter. So with the sort of Lee Optical presumption of constitutionality, we go full Holmes. So long as this law passes the legislative process and it doesn't touch footnote 4, it's upheld, right? I've used the phrase rational basis review. Randy calls this, I like the phrase, conceivable basis. Conceivable basis, that there's some conceivable basis why this law exists, and that's enough for the court to proceed. Okay? They might have intended this to be a proper law. Okay? Here's the language from Justice Douglas. It is enough that there is an evil at hand for correction, and that it might be thought that the particular legislative measure was a rational way of correcting it. In other words, if there's some problem and the government thought this might be of addressing it, that's enough. That will always be the case, right? 100% of the time, this test is satisfied. Maybe 99.9, I don't say 100, but 99.9% of the time, this test will be satisfied. Justice Douglas says the court will no longer strike down state laws because they might be unwise, improvident, or out of harmony with a particular school of thought. He writes, protection against abuses by legislatures, the people must resort to the polls, not to the courts. This is Justice Holmes, right? Holmes prevailed, 40, 50 years after Lochner. This is Holmes. They adopt full Holmes for economic rights. Again, footnote 4 still exists for the off-ramp for certain certain democratic type rights, but here they say for economic rights, we are not getting involved. Right? So if there's some sort of political process shutdown in footnote 4, we'll give it scrutiny, but for everything else, we're out of the business. The court would abide by this rule for about 3 or 4 years. If you're reading for next week, is that next week? Griswold, right? No, maybe later. We'll get to Griswold later. No, you do. What are you doing on Wednesday? Oh, I'm sorry, we skip it. We'll come back later. We'll come back later to Griswold v. Connecticut, which is a case involving contraception. The court throws this doctrine sort of out the window and say, well, you have unenumerated rights. We'll give it heightened scrutiny sometimes. For contraception, we'll give it a heightened scrutiny, but not for economic rights. But at least as far as 1955 goes, the court said, we are out of the business of giving any meaningful review to unenumerated rights. They'll hold on to that for about a decade or so. Whew. All right. Questions on Lee Optical? We gave the last, rubber stamp. Rubber stamp. Whoop. We gave the last case, the Milnot case, almost for fun, to show that even after Caroline Products and Lee Optical, courts still sometimes, that's why it's 99.9, sometimes that courts still say this is an irrational legislation. And eventually the Phil Milk Act was declared unconstitutional. I didn't know this case existed. I think I mentioned this in the reading until I talked to the granddaughter of Charles Hauser, who's the president of the Caroline Products Company. And she said, yeah, my grandfather told me this story that they struck down the Phil Milk Act. I was like, no, they didn't. Like, yeah, they did. I'm like, no, it didn't happen. So I realized, like, holy crap, they struck it down. Then Randy put in his book to give me credit, but then eventually he brought me on board. So everything worked out. A lot of my stuff was in his book, but the universe works out in the end. All right, that was a lot. Cool. Let me synthesize very briefly, right? Where are we up to this point? By the time we get to 1955, all of the economic liberty cases, Lochner and Atkins, are no longer good law. Once you get to Caroline Products, the court says we will only apply the presumption of constitutionality. We will not apply the presumption of constitutionality if you have one of these democratic problems, but generally you apply it. And then once you get to Lee Optical, the court says we will defer to all rights, all cases, all government actions, unless you have a democratic process breakdown. So the courts at this point are saying we are hands off the due process clause. That's no longer our business. Justice Holmes prevails. Okay. They're not saying Buck v. Bell, though, citing every other case, but it's the same idea. All right, questions? Anything? I will see you all on Wednesday. Thank you so much.